welcome to another episode of this particular video. By name, I am Japhet Okaka Ebosetale, and today, under criminal law, we are going to be looking at elements of an offense under criminal law, and we'll be looking at the Actus Reus and the mens rea. So before moving forward, you need to first of all understand the meaning of elements of an offense. So element of an offense simply means the ingredients, the factors that must be present before the accused can be said to have actually committed an offense. They are the ingredients, they are the factors that must be present before the accused can be said to have committed an offense. And these ingredients are the Actus Reus and the mens rea. So these are the elements of an offense. Then let's move forward. You will see that in the early days of criminal law, what it is was a system of strict liability. So what this place is trying to tell us that back then, in the olden days, it was simply based on strict liability. The intention of a man, the intention why the defendant committed the offense was never placed into consideration. It was just based on strict liability in the olden days. Now, moving forward, an offense back then was not only considered as an offense against the state, but also against God. So back then, in the olden days, an offense was not only against the state, but also an offense against God. Under this system, there were three features. So back then, in the olden days, there were three features. Number one is strict liability. Where Mr. A commits an offense, it was just simply based on his Actus Reus. It was simply based on the act. The intention was not placed into consideration. So back then in the olden days, it was simply based on the Actus Reus. Punishment was based on strict liability. So moving on, you also see that back then there was nothing like omission. Unlike now, whereby neglect to prevent a felony is actually an offense. You can see that in section 515 of the criminal code. Back then, if for example Mr. B sees Mr. A killing somebody and he does not report to the police, despite the fact the police station is close by, he won't have. In that particular scenario, Mr. A will be said not to have committed any offense, despite the fact he saw Mr. B killing somebody else. But now, looking at section 315 of the criminal code, it is actually an offense for Mr. A to see Mr. B killing somebody and the police station is close by and he didn't report to the police station. So our omission back then was not an offense, but right now omission is considered a crime. So this is why omission, not doing anything at all, could not constitute an offense back then, while now when neglect constitutes an offense. So moving on, you also see the third feature of the olden days criminal law was that there was severity of punishment and the intention of the offender was not considered as material proof. So as I've stated earlier, in the olden days, it was simply based on the Actus Reus. The mens rea was not placed into consideration. The intention of a man was not placed into consideration. Now, you will ask me, why was the mens rea not placed into consideration? Let's look at the dictum given by Brian C.J. Now, look at what Brian C.J. said. He said, even the devil himself knows not the heart of a man. So Brian C.J. is trying to say that even the devil does not know the heart of a man. So how we humans, they know the intention, they know the heart of a man. That is why in the olden days, it was simply based on the Actus Reus. It was simply based on the conduct. It was simply based on the defendant acts and not the intention, because it was said that the intention of a man could not be known. So that is why the intention was not considered. Now, let's move forward. You see that subsequently some petitions were made to tamper justice with mercy. So subsequently there were petitions stating temper justice with mercy, temper justice with mercy. This made the common law courts come up with a common law margin. So for this particular reason, due to the petitions that were written, say temper justice with mercy, temper justice with mercy, a particular Latin margin was created, which is Actus non facit rum nisit me sit re, which is a person is not guilty of an offense unless he be so in intention. This simply means that from now on, it is not only the Actus Reus that is to be placed into consideration. A person is not guilty of an offense simply based on the Actus Reus. He must also have the intention. It must also have the mindset. It must also have the heart of committing that particular offense. So for that particular reason, the mens rea was now placed into consideration. So for element of an offense, we are now going to look at the Actus Reus and the mens rea. So let's then move on to the Actus Reus. So right now we are now looking at the Actus Reus. Now, this is the overt or obvious act done which is for the purpose of forgery crime. Intent. It can be the extent, it can be the existence of a state of affair, and can also be the omission. The Actus Reus can also be an actual act or an omission. So you see, the Actus Reus can be an act on one hand and can also be an omission. So it is not only an act that constitutes the Actus Reus, it is also an omission. Failure to fulfill a duty imposed by law is also considered Actus Reus and not only an act. Now, there's a particular, let's move forward. The injury or death of another's property by moving the property or the consequences of an act. E.g., let's look at this particular scenario. So you will tell me if actually Actus Reus was present. Let's look at a particular scenario. Mr. A saw 1,000 naira on the ground. On top of a table in their lecture class. He saw 1,000 naira on the ground, thinking that this 1,000 naira belongs to Mr. B. He picks the 1,000 naira, not knowing that this 1,000 naira actually belongs to me. In that particular scenario, is there an Actus Reus? In that particular scenario? Mr. A picks 1,000 naira from the floor, thinking that the money belongs to Mr. B, in not knowing that this money actually belongs to me and not Mr. B. So in that particular scenario, is there an Actus Reus? Now let's answer this question. Example, Mr. A takes 1,000 naira he found in the room of Mr. B with the intention to deprive Mr. B of the ownership of the sum without knowing that the 1,000 naira belongs to him, having fallen off from his pockets. At the point of taking the 1,000 naira, the mistaken belief that the act is unlawful, that is, the money belongs to Mr. B, is immaterial. So it does not matter whether there was a belief that the money actually belongs to Mr. B. In that particular scenario, there is no Actus Reus. It does not matter that Mr. A thought that the money belongs to Mr. B. He thought that the money belongs to Mr. B. So there is an Actus Reus. No, in that particular scenario, there is no Actus Reus. So for Actus Reus, you must also note that for Actus Reus, the consequence of an act and not the act itself constitutes Actus Reus. So for Actus Reus, you must note that the consequence, the end result of an act constitutes the Actus Reus and not the act itself. Explaining this, involve, okay, Mr. A picks a gun, he turns around and shoots Mr. B. Now, what's the Actus Reus in that particular scenario? It is the death of Mr. B that is the Actus Reus. It is the result of shooting the gun that is the Actus Reus, and not the act of picking the gun, turning around before shooting Mr. B that constitutes the Actus Reus. So for Actus Reus, you can see that the consequence of the act, the end result of the act, constitutes the Actus Reus, and not only the act itself, and not only the conduct itself. So the consequence also constitutes Actus Reus. Now, for Actus Reus, the persecution, so for under Actus Reus, the persecution must be able to prove, the persecution must be able to prove that the injury suffered by the defendant was as a result of, suffered by the victim was as a result of the defendant's behavior. And this is why the theory of causation came into place. So we have the theory of causation, the theory of causation, which means that for this particular theory, it simply means that for the defendant to be held guilty, for the defendant to be held liable for a particular punishment, the injury must have resulted from the conduct of the defendant. The defendant conduct must be what caused the injury suffered by the victim. It must be because of the defendant behavior, the defendant conduct, the defendant act that resulted in the victim having such injury. So this is why the theory of causation was formed. And under this theory, we have the factual causation and legal causation. So we have factual causation, and also we have legal causation under the theory of causation. So when considering causation, there are 5 terms to determine whether causation can be established. 2 of these are factual causation. So under factual causation, we have 2. We have sub 2. Then under legal causation, we have 3. So what does factual causation speaks about? What does factual causation speaks about? Factual causation just speaks about the fact that the injury suffered by the defendant, suffered by the victim, was as a result of the defendant's behavior. The victim suffered that injury because of the defendant's behavior. That is what factual causation is talking about. The injury was caused. The injury was caused by the defendant. That is what factual causation is speaking about. It was the defendant's conduct that resulted to that injury. That is it for factual causation. However, for legal causation, it simply have to do with that the defendant must be held liable for the consequence. What this legal causation is speaking of is that the defendant should be held guilty. The defendant should be held liable. That is what legal causation is speaking about. So for factual causation, it is divided into 2. Factual causation is divided into 2. Legal causation is divided into 3. Why? All this, you must remember that all these are to prove that Actus Reus existed. All these are to prove the existence of Actus Reus. All these are to prove that it was because of the defendant's behavior that the victim suffered an injury. So for factual causation, which is divided into 2, so let's now look at factual causation, which is divided into 2. Now, for factual causation, it is divided into the but-for test. Into the but-for test. That is number 1. We have the but-for test as number 1. What does the but-for test speaks about. So the but-for test simply speaks that it was because of the defendant's behavior that the victim suffered an injury. Now, let's look at a particular scenario for you to understand the but-for test clearer. Now, let's look at this scenario. Mr. A tries to slap Mr. B, and Mr. B dodges the slap, and in the process of dodging the slap, he falls down on the ground and hits his head. Now, you get this scenario. Mr. A tries to slap Mr. B. Mr. B, in the process of dodging the slap, falls on the ground and hits his head and suffers an injury. Now, Mr. A will be relying on the fact that the injury suffered by Mr. B was not because of my slap. That is what Mr. A will be saying. Mr. A will say, I tried to slap Mr. B. Mr. B dodged it. The injury that suffered from Mr. B head did not come from my slap. That is what Mr. A will be saying. However, the but-for test then comes into play. The but-for test then comes into play. And the test is that, but, that's the test now. But if you did not attempt to slap Mr. B, if Mr. A did not attempt to slap Mr. B, when Mr. B suffered that injury, that is why it is called the but-for test. But how which you did not attempt to slap Mr. B, when Mr. B suffered that injury. That is why it is called the but-for test. But now let's continue. Paraphrasing, the court is generally trying to consider whether the consequence would have resulted regardless of the defendant action. The court will be considering for this but-for test whether the consequence would have resulted regardless of the defendant action. That is why it is referred to as but how which you did not attempt to slap Mr. B. Once that injury have occurred, that is why it is referred to as the but-for test. Now, let's move forward. If the answer is no, the result will only have occurred due to the actions of the offender. The factual causation is one step being established. For if, however, the answer is yes, that the result would have occurred anyways, then the factual causation is not established. Now, what is the meaning of that? For better clarification on this but-for test under factual causation, let's look at the case of Arrow versus White. Let's look at the case of Arrow versus White. Now, in the case of Arrow versus White, the defendant laced his mother's drink of milk with poison. So the defendant, in the case of Arrow versus White, took poison and placed it in his mother's drink. However, she did not drink the drink. However, the mother of the defendant did not drink the milk, but died later from a different cause. Since the mother would have died regardless of the fact that he poisoned her drink, he was acquitted of murder, as factual causation could not be established. So in this particular case of Arrow versus White, the defendant took poison, placed it in the drink of his own mother. However, the mother did not drink the drink, but she died later on. She did not drink the drink, but she died for another reason entirely. So in this particular case, the court held that the defendant was not guilty of murder. Why? Because the death of the mother was not as a result of the defendant action. That is why it is called the but-for test. Now, the court will say, but okay, yes, the defendant poisoned the mother's drink. Yes, but the death of the mother arise due to the fact that the drink was poisoned. But did the death of the mother occur due to the actions of the defendant? The answer is no, because simply the mother did not drink the poison. So this is why it is referred to as the but-for test. The court look at the word but Mr. A tries to slap Mr. B. Mr. B dodges, fell on the ground and injured. The court will say, but how would you do not attempt to slap Mr. B? When Mr. B have suffered an injury in the first place, even though the injury was not as a result of your slap. That is why it refers to as the but-for test. Now, in this case, the defendant poisoned his mother's drink. The mother did not drink the drink, but died for another reason entirely. Now, the defendant is being tried for the murder of his mother. Now, the court will apply the but-for test. But-for test. Yes, the defendant poisoned the mother's drink, but did the mother die because of the poison? The answer is no. So this is why it is referred to as the but-for test. Now, let's now look at, because we said there are two components under factual causation. So let's now look at the second one under factual causation, which is the diminished principle. The diminished principle. The diminished principle. So the diminished principle simply talks about for the defendant to be held guilty of an offense, his actions must be more than minimal. That is it for the diminished principle. Before the defendant can be held guilty of a particular offense, his actions, his conduct must be more than minimal. Now, let's move forward. The second test of factual causation is that the requirement that the defendant's actions must be more than a minimal cause of the results. Now, there's a particular scenario here. If Mr. A pushes Mr. B to the road, Mr. A pushes Mr. B to the road, and now Mr. B is on the road, and a vehicle is coming, and Mr. B dodges the vehicle, and due to the fact he jumped and dodged the vehicle, he broke his leg. In that particular scenario, is Mr. A actions more than minimal? If you look at this particular scenario, you see that Mr. A's actions is just a minimal, is minimal. But now, let's now look at the case of Arrow versus Paget for better clarification. Let's look at the case of Arrow versus Paget for the diminished principle. Now, in the case of Arrow versus Paget, Paget was escaping some armed policemen. So in this particular case, Paget was escaping some armed policemen while also firing back at them. By trying to escape and hide from them, he ran up to his flat where his heavily pregnant girlfriend was, and used her as a shield against the police. He was found guilty to have factually caused her death, as his actions of firing on the police were more than a minimum cause. Now, let's go back to that previous scenario. You see that Mr. A and Mr. B walking. Mr. A pushes Mr. B to the main road. Mr. B tried to dodge a vehicle, broke his leg. In that particular scenario, you can see that the defendant's action is just minimal. It's just a minimal action. But in this particular case of Arrow versus White, in Arrow versus Paget was running away from some police officer and also firing back at them, meaning that he was aware that the police officer are firing at him. So he was also firing at them. So in this case, he ran up to his flat, saw his heavily pregnant girlfriend. His girlfriend was heavily pregnant. Now, what was his action? He used his girlfriend as a shield against the police bullets that were coming forward. Now, if you look at this particular case, you will see that the defendant action was more than minimal. So the diminished principle is trying to say that for the defendant to be held guilty of a particular offense, his actions, his conduct must be more than minimal. Now, you'll see a particular question asked by one of our learned friend and colleague, where he said that how do you measure the the defendant action, how do you measure it to know whether it was more than minimum? So in my own opinion, I would say it's with a reasonable man's perspective. Just like in the first scenario where you saw that Mr. A pushes Mr. B to the main road, Mr. B dodges one vehicle, and because of that he broke his leg. In that particular scenario, from a reasonable man perspective, you will be able to deduce that the defendant action was below minimum, was just a minimum action. But in a scenario whereby Pagent, in the case of Arrow versus Pagent, uses his heavily pregnant girlfriend and as a shield, with the word shield, as a shield against bullets, he was aware that his girlfriend was heavily pregnant and yet still went on to use her as a shield while also firing back at the policeman. In that particular scenario, from the reasonable man perspective, though there is no measurement, you can be able to see that that action of the defendant was more than minimum. So that is it for factual causation. So for factual causation, under causation, we have the but-for test on one hand, and we also have the diminished principle on the other hand. Now, let's then look at legal causation. Legal causation. So, under legal causation, it is divided into three. The three tests of establishing legal causation is 1. The Tin-Score principle. The Tin-Score principle. While number 2 is the operative and substantial test. That is for legal causation. Now, the number 3 is the Novus Actus Intervenis test. So for legal causation, which is divided into 3, so you must not confuse it. For factual causation, it is divided into 2, but-for test and diminished principle. For legal causation, it is divided into 3, which is the Tin-Score test, the operative and substantial test, and number 3, the Novus Actus Intervenis test. So now let's first look at the Tin-Score test. The Tin-Score test under legal causation. Let's then look at the Tin-Score test. Now, under this rule, the defendant must take his victim as he find him. So the Tin-Score test is also similar with the eggshell principle. It simply means that the defendant must take his victim as he finds him. Now, let's then look at, for better clarification, let's look at the case of Arrow versus Hayward. The case of Arrow versus Hayward for better clarification on the Tin-Score test. Now, in the case of Arrow versus Hayward, the defendant chased his wife out of the house, shouting threats at her. So in this particular case, the defendant chased his wife out of the house and he was also shouting threats at her. So on her way out, she collapsed and died. He did not physically touch her. So you see it, the defendant in the case of Arrow versus Hayward was shouting at his wife, chased his wife out and also shouted threats at her. So subsequently, she collapsed and died. The defendant did not physically touch her. He did not physically touch the wife. He was just shouting at her, shouting threats at her. So he did not physically touch her. She was suffering from a rare thyroid condition which could lead to the death, where physical exhaustion was accompanied by fright and panic. Both the defendant and the wife were unaware that she had this condition. The court held the defendant liable for constructive manslaughter as his unlawful act caused the death. The eggshell score rule applied. He was therefore fully liable despite the fact an ordinary person or reasonable fortitude would not have died in that condition. Now, what does this Tin-Score principle say? It simply says that you take the defendant as you take the victim as you find him or her. So in this particular case of Arrow versus Hayward, the defendant chased his wife away. So the defendant chased his wife away, and he was also shouting threats at her. He was threatening her. So on her way, the victim fell down and died. The defendant did not touch her. He did not use anything to hit her. He just only chased her away and was also shouting at her, unaware that his wife had a particular condition, had a particular sickness which made her to die. So under the principle of under the things called, which is take your victim as you find him, the court held the defendant liable. The court held the defendant guilty, even though he did not physically touch her. So now let's look at a particular scenario, like a particular scenario whereby Mr. A tries to prank Mr. B. Now this is a better clarification. Mr. A tries to prank Mr. B, unaware that Mr. B have a high blood pressure. So Mr. A saw Mr. B coming and just shouted, ah! And Mr. B, suffering from high blood pressure, quickly suffers it and fell down and died. So in this particular scenario, you will see that these things called rule we apply, which simply means take your victim as you find him. It does not matter whether this person that died suffered from a high blood pressure, was suffering from a high blood pressure, or if you have pranked another person, if you have pranked a healthy person, he would have not died in that condition. Yes, that is what the defendant will be saying. But the skill score principle will say no. Take your victim as you find him. How wish you did not prank him in the first place. Now we are going back to the but-for test. So how wish you did not prank him in the first place? Would he have died? That's the but-for test. So, but the T-score principle is just simply the eggshell principle. Is just simply trying to say take your victim as you find him. It does not matter whether he was suffering from high blood pressure. Just take your victim as you find him. It does not matter how wish you prank Mr. C that is heading. He would have not died. Just take your victim as you find him. Now, that is it for the T-score test under legal causation. Now, what's the second one? What's the second one? So, for the second one, under legal causation, we have the operative and substantial cause. The operative and substantial cause. Now, the operative and substantial cause, in the case of multiple causation, the test to be used for whether the causation element of the Actus Reus is satisfied is the substantial cause test, which is formulated as follows. Now, the operative and substantial cause test simply states the fact that if at the time of death, the defendant act was substantial and operative cause of death, then the defendant will be deemed to have committed the offense. That is what the operative and substantial test is talking about. Also, the operative and substantial test is also say this extends to a situation where the act of the defendant brought about a future event. Now, let's explain the operative and substantial test very well. Now, look at this particular scenario whereby Mr. A points a gun at Mr. B. Mr. A points a gun at Mr. B, and Mr. A points a gun at Mr. B, and he started firing the gun towards Mr. B. So Mr. B is dodging the bullet. So in the process of dodging the bullet, he jumps and enters another person's compound, and he continues running in attempt to further dodge the bullet. As he was running in this person's compound, a dog saw Mr. A running and pursues Mr. A. He pursues Mr. A and bites Mr. A. Mr. A keeps on running, dodging the bullet fired by Mr. B, and in an attempt to cross the road, a vehicle hit him and died. So the operative and substantial test is trying to say that Mr. B will be held guilty of the offense, even though that it was not Mr. B that finally killed him, but however, it was the act of Mr. B that caused the future event that occurred. Now, that is why it is stated that this extends to a situation where the act of the defendant brought about a future event. E.g., exposing the victim to new danger. So Mr. B was firing the bullets at Mr. A. Mr. A was dodging the bullet. He jumped into a compound in an attempt to further dodge the bullet. And a dog saw Mr. A coming and he pursues Mr. A, bites Mr. A. Mr. A is now injured, could not walk properly. He continued struggling, and before you know, in an attempt to cross the road, a vehicle hit him. Now, you can see the future events, but the operative and substantial test is trying to say that though it was not Mr. A, not Mr. B that kicked Mr. A, but it was Mr. A's act that resulted in the future event, and for that, Mr. B will be held guilty for killing Mr. A because it was his act, it was his conduct that resulted in the future event. Now, that is it for the operative and substantial test. Now, let's now also move forward. This also extends to acts done involuntary of the defendant action or as self-defense in response of the self-defense in response of the defendant action. So in the process of the victim trying to defend himself from the defendant behavior and he injures himself in that process, the defendant will also be held guilty of committing that offense. Now you must note this. The chain of causation will only be broken if a completely coincidental event such as an act of God, or if the victim completely overreacted. Now, that's an exception to the chain, to the operative and substantial test under legal causation. This is trying to say that the chain of causation, we earlier said that if the defendant acts, if the defendant behavior caused the injury, if the defendant behavior resulted into a future injury of the victim, the defendant will be held guilty. That's why I gave the example of Mr. B firing at Mr. A, and Mr. A dodging the bullets, and a dog sighted him, pursues him, and bites him, and he is now injured. In an attempt to cross the road, a vehicle hits him. Now, the operative and substantial test will hold the defendant guilty. However, there is an exception, which is the act of God, and when an act of God occurs, the chain of causation will be broken, or where the defendant or the victim simply overreacted. Now, what does this mean? Let me give you a scenario. It's just like in a scenario in which Mr. A fires a gun at Mr. B. Now, Mr. A is firing a gun at Mr. B. Mr. B is running from the bullet. He's running. He left Edo State in attempts to dodge the bullet. He left Edo State, went to Benin City, from Benin, went to Lagos, and now he's also saying he's dodging the bullet. Now that's overreaction. So he's dodging the bullet from Lagos. He went to Abuja. Mr. A did not follow Mr. B, but Mr. B is simply just overreacting. He's saying that I'm dodging the bullet. So he entered his vehicle. He went to Benin. From Benin, he went to Lagos. From Lagos, he went to Abuja. So in Abuja, he got an accident and died. So in that particular scenario, you cannot say that Mr. A is guilty of that offense. That was overreaction to some extent. That was overreaction. You can't just say I'm dodging the bullet. That is why you enter the vehicle, went to Lagos to Benin. Mr. A did not follow you. Benin to Abuja, you were just driving the vehicle until you had an accident. It can be said to be an overreaction or an act of God, which is another different thing entirely. So that is the operative and substantial test in a nutshell. Now let's look at the third one, which is the Novus Actus Intervenis. Now the Latin word means new intervening acts. So this Novus, which is the third one under legal causation, the third one, Novus the word novus actus intervenis simply means new intervening act. It is an independent event which, after an offender's act has been concluded, either caused or contributed to the consequences concerned. Now, let's move forward. A requirement of an act or omission committed after the initial offender's act to constitute a novus actus is that the secondary act will not reasonably be foreseeable. Now, let's also move forward. As a novus actus is an independent intervening event, independent intervening act. So you must know that for this third one, which is novus actus intervenis, it is an independent act. It is a new event entirely. Now, the general category also includes the injured party himself, another third party, or even an act of God. So those capable of committing a novus actus intervenis is either the victim himself, a third party, or an act of God. Now, let me explain it. The victim himself under the novus actus intervenis, it simply means that, now let's look at this scenario. Mr. A and Mr. B are fighting. Mr. A and Mr. B are fighting. Mr. A blows Mr. B, injures Mr. B's leg, break his leg, and Mr. B was rushed to the hospital. So Mr. B with one leg is currently on the hospital bed, and the cleaner is cleaning the floor in the hospital, and Mr. B stand up. He says that he wants to go and urinate, and the cleaner tells Mr. B, you are injured though. See, your leg is injured. See, the ground is wet. You might fall down and break your leg. So Mr. B said, no, I want to urinate. He gets up. He started walking with one leg, and due to the slippery fall, due to the fact that the ground was watery, he fell down and died. So in that particular scenario, you can see that that is a novus actus intervene. It is an independent act on its own. It is a new act. It is an independent act on its own, not caused by the defendant. So this particular principle is trying to say that the defendant will not be held guilty if that kind of thing occurred. That the novus actus in the scenario I gave recently was caused by the victim himself. It was not the defendant that brought about the victim death. Yes, the defendant, Mr. A, broke Mr. B's leg. He broke Mr. B's leg. However, it was because of Mr. B's conduct that resulted in his death. So this particular principle is say that event that occurred entirely at the hospital is just a novus actus. It is on its own. It is an independent act. The defendant should not be held guilty for that kind of act. It should just be held guilty for the one that he caused to the victim, which is breaking his leg, and not the act that happened in the hospital. So that is it for novus actus. Another thing you must note is that novus actus can be caused by the victim himself, like the person in the hospital. Novus actus can also be caused by a third party. How can it be caused by a third party? Now let's look at this scenario. Mr. A is riding his bike on a lonely road. Mr. A is riding his bike on a lonely road, and subsequently he was robbed. He was attacked in the process of riding his bike on that road. He was attacked by Mr. B. Mr. B came, attacked Mr. A, took his bike and slapped him, took his money from him. Then Mr. B drove the bike away, leaving Mr. A on the road injured. Now that have happened. So as Mr. A is on the road injured, bleeding, then Mr. C comes with his vehicle driving recklessly and hits Mr. A, and Mr. A died. So what this novus actus intervenis is trying to say that Mr. B have done his own. Mr. B have done his own of robbing Mr. A. That is Mr. A's own. that is Mr. B's O, robbing Mr. A. But the acts, yes, I wish Mr. B never robbed Mr. A. Maybe his death should not have occurred. But the Novus Actus Intervenis is trying to say that that act, that stuff that occurred, is entirely on his own. It is an independent act on his own. Mr. C that killed Mr. A will handle that one. Mr. B robbing Mr. A will handle that one. Mr. B should not be charged for murder of Mr. A due to the fact I wish he never robbed Mr. A. Mr. A would have not died. So that is on his own. That is what this particular theory is saying. So you remember the things called principle, which is say that take your victim as you find him. Remember the operative and substantial test, where the defendant conduct resulted in a future event. The defendant can be held liable for punishment. And you also remember the Novus Actus Intervenis, which simply means when an independent act occurs, that independent act is on its own. The defendant should not be held guilty of another person's behavior. So that is it for the Novus Actus Intervenis. So this is it under mens rea. This is it under Actus Reus. So we have only spoke about Actus Reus alone. So under Actus Reus, under elements of an offense, we looked at Actus Reus. And for you to actually deduce that an act was committed by the defendant, for you to actually deduce that this injury was caused by the defendant, the theory of causation was brought, which is factual causation and legal causation. They also said under factual causation, we have two, the but-for test and the diminished principle. The but-for test, simply the court look at the question, but if Mr. A never did this, would Mr. B have suffered that injury? Now, that's the but-for test. The diminished principle is simply trying to say for the defendant to be held guilty of an offense, his acts must be more than minimum. That is it for the diminished principle. So now we are done with factual causation. Then we now look at legal causation, where we said it is divided into theory, which is the things called principle, the operative and substantial test, and the Novus Actus Intervenis. Now, this is it under Actus Reus. So we are done with Actus Reus. So the next thing we are going to look at is the mens rea. So we are now going to look at the mens rea.